Well, I think we can begin.
Good afternoon. This is Equin,
Hi.
and happy International. Thank you. I will begin the countdown now. We are ready in 3, 2, 1.
Good afternoon, everyone. Welcome back to the Montgomery County Council, and thank you all for joining us. Today, we'll vote on a position on Local Bill MC 1421 and accept a briefing from OIR on police reform bills in the General Assembly. I want to thank Central Staff and OIR for working on the packet that's in front of us, and I will turn it over to Carolyn Chen to go through the packet. Carolyn.
Thank you, Mr. Hucker. This is Carolyn Chen, Legislative Analyst with Central Staff. Our first overview and update will be on the Public Campaign Financing Bill, MC 1421. I'm going to have Christine Wellens, Ms. Wellens, and Kathleen Boucher give us a full update before our position vote.
Thank you, and good morning. This is Christine. So regarding this local bill 1421, you'll recall that the council took a look at this bill initially back in November and decided to hold any position pending further information about the fiscal impacts of the bill. And as you'll recall as well, this is enabling legislation that would allow Montgomery County to include within its public financing system the clerk of the circuit court, the register of wills, the sheriff, and the state's attorney. In terms of fiscal impact, the county's OMB did take a look at the bill, but since it is enabling legislation, the economic impact was uncertain. I mean, the fiscal impact of the bill itself is zero because it doesn't require the county to implement a public campaign finance system. But obviously, if the county decides to do so, then there would be a fiscal note associated with that. The state fiscal note stated that if Montgomery County elects to create the public financing system pursuant to the enabling legislation, then there would be significant costs, quote unquote, significant costs associated with that. But the state also did not provide specific financial data because, again, it is enabling legislation and doesn't require the county to do anything, just permits the county to extend the public financing system. And I would invite Ms. Boucher to add anything that I've overlooked, and we're happy to try to answer questions. Thank you.
Thank you, Christine. No, you did a great job there explaining the bill. It is, there was a public hearing in early February in Ways and Means. It's still there. It has been approved by our House delegation, and our Senate delegation has not yet taken a position. But thank you, Christine. You did a nice job.
Councilmember Reamer.
Thank you. I don't know if I need to make a motion, but I've moved support of the bill. You know, the question of who should pay for these campaigns is a good one. I think the state should pay for them. They should encourage local communities to create public finance systems, and they should be willing to pay for state offices under those systems. I'm not sure how likely that is. You know, the author says it's not likely at all. But I thought we could just wrap this one up real quick and move support of the bill. And if others want to move the amendment, that's fine. But I'm going to start with the motion.
Councilmember Reamer, is there a second?
Second.
Councilmember Jawando seconds. Okay. Any discussion? Councilmember Friedson.
Yeah, thanks. I do think, I mean, if our position is that we think that the state ought to fund it, then that ought to be our position. I mean, we don't vote, you know, we don't vote on formalities here. We're not in the state General Assembly. So our position should be our position. And if our position includes the belief that state positions ought to be funded with state appropriations, and I think that we should include that in our position statement. All this really is a position that we're taking, and I think it should be fully inclusive of what our position is. So I'm comfortable supporting it, but under the context that we include the full position, which is that we believe that the state ought to appropriate funds for this. This is different than the county executive and the county council. Those are established under the county charter. These positions are established under state law.
Is that a motion for the amendment?
Yes.
Is there a second?
Second.
Councilmember Rice seconds. Okay. Any discussion of that? Councilmember Albornoz was already in the queue. Do you want to talk about? Oh.
Well, since I'm next up, I support the amendment. I did speak to Delegate Lukey after our last conversation, and really appreciated the work that has gone into this particular bill, and do believe that it's hopeful that other jurisdictions across the state will follow suit. Our public finance bill has been exemplary, and I really want to credit the GO committee who led us through the process, and then we voted before full council to enact the adjustments that were made. And I think, as other parts of our country are being regressive in their voting rights and making it more difficult for residents to be able to access voting rights, this is another example of Montgomery County and the state being progressive and moving forward and ensuring that everyone feels part of this system, which is critically important on a lot of different levels. So, but the funding issue is a real one. And so I support this bill, but with the amendment of purveying funding from the state. Thanks.
Councilmember Novato.
Thank you very much, Mr. President. I too want to associate myself with what was just described. This bill, when it came to the GO committee, was a very robust bill, but the GO committee had to work extensively to modify, to strengthen it, to include things like having a commission comprised of community members to recommend the funding levels. And, we worked really hard with all of the major organizations to strengthen this bill. It was quite the undertaking. And as it was mentioned, even though all that work went into it, we had to come back and tweak a few things as well. Those of us who participated in this particular sort of debut of the public campaign finance process understood that it was not a simple process. It was quite complicated, but the issue of funding is always front and center. Obviously, we can have the most wonderful program in the world, but if the funding is not there at a level that would then incentivize potential candidates or people who want to run for office, et cetera, to participate, then we have done nothing. And so I do think that making the statement around this issue of funding is going to be important. As all of you know already, we are going to be facing very soon, believe it or not, another election cycle. And at this point, our current program is not even funded to the level that it needs to be funded. So again, I want to make sure that as we pursue these very worthy goals, that we're not just doing something symbolically, but that we are actually standing up and ensuring that it would be successful. So with that, I will support the recommendation to include that amendment. Thank you.
Councilmember Jawanda.
Thank you. If Mr. Friedson could just restate the amendment. What I thought I heard was that we were supporting the bill, but we would like the state to fund it. There wasn't any contingency. If they don't fund it, we're not supporting it. I just want to make sure I understood what the amendment is.
Yeah, I mean,
we're supporting it. If
we're supporting it and expect, and want the state to fund it. I mean, I'm not necessarily proposing specific language on that.
It doesn't have to work that way, right? You don't have to be a contingent.
Well, I mean, I don't think that we should say, this is what we want, but if you don't do it, we don't care. I mean, I don't think
all we do is
the message is these are state positions and the state ought to fund public financing for them. That this should be a broader value. I mean,
sure. Okay.
That's the expectation. I wouldn't want our position to be that this is what we want, but if you don't do it, we don't care and we'll support anyway.
Right. Yeah. Neither would I. That's why.
Yeah. I mean, my expectation is that this is very different than the council and the executive, because those are county charter established positions. These are state law established positions, and the state should fund the public financing for that. So, I think we should be strong in our statement about that and what our expectations would be.
Yeah, I appreciate that. And so
the amendment could say subject to the appropriation of state funds.
Well, I would not want it to say that, but that was which was my question. But I do want to say what I think I heard from Councilman Friedson was that we think these are state positions, even though they operate in the county and are elected by county residents exclusively, that they should be funded. This money for running for election should be given or be funded by the state. I am totally in support of that, as I am totally in support of all these positions, particularly sheriff and state's attorney, but all of them being going to public financing. I think they're critical decisions that are made by these folks, life and death decisions. And we should have a qualified, open pool of candidates. Associate myself 100% with the remarks of Vice President Albornoz that, this is an important step at a time when voting rights and representation of all is under attack in quite many parts of our country. So yeah, with that understanding, I would support it. I would support both the amendment and the underlying the bill as well. Thank you.
Councilmember Glass.
Thank you, Mr. President. I'm glad we are revisiting this conversation and appreciate Councilmember Reamer for re-upping it. And I too appreciate the comments of Vice President Albornoz. We need to continue working to increase access to the ballot box and increase access for candidates, non-traditional candidates. And that's what public financing in its very core does. And as has been noted, the irony of this conversation can't be lost on anybody that we do not have enough funds currently for the upcoming 2022 campaign that has already begun. And so we need to make sure that in this budget and the following budget, we have the funds available for folks to run the county executive and county council races clearly. But I think this is a step in the right direction, regardless of who ultimately funds these programs, because we should always be striving to increase access across the board. Thank you.
Councilmember Katz.
Thank you very much, Mr. President. I too support the amendment. I believe that this is important legislation, but how we're getting the funds, where we're getting the funds, how we can afford to do it should be a part of the discussion from the very beginning. And so therefore I am supportive of the amendment, and I'm supportive of the underlying legislation as well, as long as the amendment is there so that we can do it rather than just talk about it. Thank you.
Thank you. Okay, I think that's everyone. So all those in favor of support with the amendment, please raise your hand. Okay, that is unanimous. Great. So we can move on. Carolyn, are you beginning this, or should I turn it over to the chief?
Mel's great for this.
Okay, Mel.
Moving on to the debrief.
The chief. Okay, I'll start in really quickly.
Sorry, Mel. Thank you.
So no problem. So quick update on the 2021 session. What's left on the General Assembly's to-do list? The operating and capital budgets. There's a KER-1 2.0 bill coming in, and we've not seen it yet. So we just looked. It's not here yet, but that's going to be something that they're going to need to work on. Sports betting is something that we've not been very involved in, but has been a major conversation in the General Assembly. It looks like the House has a bill that's coming to the floor about that this year or this week. Guidelines for the money that we believe the House of Representatives will thumbs up hopefully tomorrow, the big federal bill that passed the Senate over the weekend. And then police reform, which where that stands, we are going to talk about the Senate package today. And I will tell you that the House passed its package, the House Judiciary passed its package condensing everything they intend to do into one bill on Friday night. We expect to see that bill out probably on the House floor, maybe tonight or Tuesday. So if you're good with that, I'm going to go ahead and roll right into the Senate package, Mr. President.
I bet we're good with that.
Okay, and then I want to let you know also who's on the call with us, in case we want to, in case you all want to engage them in answering questions or supportive information. I believe the Chief Jones is on, Mark Ermey, Jordan Satinsky, both with MCPD, and Ed Lantner, who you all know with our County Attorney's Office. So what we've done in the packet is go through each one of the Senate bills, and we've described them. So what we're going to do is just, you're good with this, start on the first bill, which is the Maryland Police Accountability Act of 2021. It's the body worn camera bill, and we'll just run through the package and see where we land. And I'm going to turn it over, unless someone's got any questions about that plan. Kathleen and I will go through the package, and this first bill, Kathleen's going to talk about.
Thanks,
Matt.
Mr. Hucker.
Yes, Councilmember Reamer.
I just want to suggest that the disciplinary package is the one that I hope we'll have time to talk through. And so these other items are important. But if we are seeming to run out of time, I just hope we'll get a chance to make sure we talk about the disciplinary items. Thanks.
Mr. President, if you prefer, we can take the LEOBR bill first. It's the last one. But if you'd like to reverse the order, we could start with that.
I think that makes sense.
Okay. Okay.
I doubt there's any objection.
Okay.
Okay, thanks, Bill. So we're looking at Senate Bill 627, which is on page 8 of the memo that Melanie sent to Council. And so this bill does repeal the LEOBR, the Law Enforcement Officers Bill of Rights, and it replaces that current act with new rules regarding police investigations and discipline. And there are three key goals in this Senate bill that were kind of spoken to in particular on the Senate floor in terms of what the bill is trying to do. And one is to make the chief more responsible and accountable for discipline in their respective departments. Another is to ensure uniformity throughout the state, including preempting local laws and prohibiting collective bargaining on anything related to police discipline, investigations, interrogations, etc. And also ensuring significant civilian involvement in the hearing board process. So we have outlined some of the key details of the bill. As you can imagine, it's very comprehensive, but hopefully captured most of the key details in the memo. You can see in the memo a definition of disciplinary actions. So any of these actions would be what triggers an investigation under the new law. It does apply broadly to police officers of all kinds, whether it's cities, municipalities, state agencies, state police, higher education institutions, etc. On preemption, the bill is very, very clear. It supersedes all state and local laws that conflict with the bill, except laws relating to the Maryland Public Safety and Training Commission. It expressly preempts local laws with one limited exception, and that exception would be to allow a local governing board to enact a local law governing investigation, interrogation, polygraphing, and drug and alcohol testing, as long as those laws don't conflict with anything in the bill. And that was essentially, there was essentially a choice between putting a lot of details in the bill that are currently in the LEOBR about when testing can occur, when polygraphing can be done, how interrogations are handled. And so a lot of the details that are currently in the LEOBR, some of them are not in the bill, the Senate Bill 627. So this local law authority relates to that that space between what's in the bill and what hasn't been addressed in terms of handling interrogations, polygraphing, drug and alcohol testing, etc. The bill does specify this is the exclusive means of disciplining an officer. It expressly provides that a governing authority, an LEA or governing authority, may not enter into a collective bargaining agreement regarding discipline, regarding investigations, interrogation, polygraphing, drug and alcohol testing, but in association with any disciplinary proceeding. It does take effective immediately upon enactment. It's an emergency bill, so as soon as it's either signed by the governor or becomes law without his signature, or is vetoed next session, depending on what happens, or this session, depending on what happens. And it does not apply to existing collective bargaining agreements, but would apply, to renewals or openers, etc. It does not apply to a disciplinary matter regarding alleged misconduct that occurred before the effective date of the bill if a hearing board is already convened before the effective date. It outlines LEA officer rights that officers still have. Again, that's on pages 9, 10 of the memo. In terms of the internal investigation itself, I think the next couple points are the highest profile points that have been followed by a lot of folks. The internal investigation must be conducted unless an officer has been convicted of certain crimes. And if an officer has been convicted of certain crimes or received a probation before judgment, then an investigation doesn't have to occur before the chief imposes discipline. But except for that category, an investigation has to be performed by a sworn law enforcement officer or a person who's not a sworn law enforcement officer but's been trained by the Maryland Public Safety Training Commission. The chief, the bill outlines processes there, including notice to an officer, meetings between the chief and the officer, how to provide a written statement of the chief's decision, but essentially the chief must make a decision about the findings of fact and evidence that leads to the chief's conclusion about whether the misconduct has occurred or not occurred. The chief, after providing notice to an officer about the allegations, the findings, and the proposed discipline, the officer has a choice of selecting a hearing board. The hearing board is a 3-member board appointed by the chief that includes 1 officer of higher rank, 2 civilians who have received training from the Public Safety Training Commission, who are not employed by any law enforcement agency, and who currently have no affiliation with the chief, law enforcement, or the matter to be reviewed by the hearing board. And the hearing board issues findings of fact and recommendations regarding discipline. The findings of fact are final. The disciplinary recommendations are exactly that. They're recommendations, and the chief has final say on the actual discipline. The finding that an officer did not commit the alleged misconduct, an acquittal is considered a finding of fact and is final. So the bill includes a statute of limitations. It sets out a process for minor policy violations that don't have to follow that formal investigation process. It does allow for expungement, and an officer who, when the charges are found to be unsustained by a chief, those records can be expunged. When a hearing board acquits an officer, those records can be expunged immediately upon completion. For other situations, the records of complaints and investigations can be expunged after 3 years from final disposition. So happy to answer questions or go into more details that you might see in the memo. I think I might rest there and ask for guidance from the council president as to how much more detail you'd like.
We can probably rest there and see what questions colleagues have, but Chief, do you want to jump in at this point, or?
No, at this point, I'll just stand by to see if anyone has comments or questions.
Okay, Councilmember Reamer.
Great, thank you. Well, first of all, I just want to compliment the Senate and the House. The legislature is stepping up in an incredible way. They have enacted packages that far exceed, I think, any normal expectation, and it's really exciting to see. So first of all, just want to say how important it is what they're doing and what an incredible amount of work it represents. This proposal, I want to say, Councilmember Rice and I, with co-sponsorship from Councilmember Navarro, Councilmember Jawando, introduced a bill that, on the disciplinary model, I think is virtually identical. And I understand that, in fact, Senator Smith consulted with the county attorney's team and may have gotten some feedback. But, you know, it is a huge transformation of the disciplinary process that we have, where today we have these arbitration boards that, unfortunately, research is showing across the country, the arbitration boards have really deteriorated the disciplinary process and made it difficult for departments to hold officers accountable to follow their policies and procedures. So I guess the question I wanted to ask is, this presumably, as you said, it's clear it preempts the disciplinary process. So this would establish a new disciplinary procedure that would take effect at the outset. Can you just talk about when that would take effect if this passes? And then second, the House has taken some kind of action. We're not getting briefed on that today. There is a very big difference there in the disciplinary process. And, you know, I think it would be helpful for us to get briefed on that at some point. And I think the observation about a veto is a relevant one. You know, we don't want to lose this moment, and it would be a shame if any of this got vetoed. So could I just ask about preemption and maybe ask Ed Latner anything he wanted to share?
As Kathleen mentioned, the act would apply to its perspective. It has no impact on misconduct occurring before the effective date if a hearing board has already been convened. But it also has no impact on an existing collective bargaining agreement. That does not include extensions, options to renew, or renewals. And I think the current CBA with the FOP expires in June 30. I think it's 2023.
Oh, okay. So if we want to have this same kind of policy in place sooner than that, we would presumably want to enact the local legislation.
You would have a gap.
I see. That's helpful to know. Thank you. Good. I think it's a really strong proposal. I think having the chief have the final say is really important. You know, the chief is an accountable official, and the county executive and the county council, you know that the chief reports to the elected officials of the county, and I think that is a good model. So I will leave it here, but you know, thank you, and again, just want to note this is really reflecting of a proposal that's before the body, and that was really helpful to hear that we may still, you know, there's a local hook here. Thanks.
Councilmember Katz.
Thank you very much, Mr. President. Mr. Latner, could you please clarify, if this legislation were to pass, as was just described, and you said there would be a gap, but do we have the authority to deal with the gap? This is saying that, I believe you said, that this is dealing with that we could not change it at the local level, and this allows for the current agreements to be in place. So am I misreading what you're saying? Could you please clarify that?
Making sure I was not muted. Yeah, that's an interesting question, actually, because you're right. It does have a preemption provision, but it does allow a certain measure of local control over investigation, interrogation, and polygraphing. You know, I would want to look at it more carefully in light of what you're saying, what you're pointing out, which is the preemption provision, whether the council would have the authority to fill that roughly 2-year gap. I'm not certain about that.
Well, if you could please get back to us, that's
Yeah.
obviously an important item.
It's a good catch. Maybe we could recommend that we should be allowed to fill that gap. You know, they have to go to conference, so they're not done with all of this. And we could certainly put in a request that we would be allowed to fill that gap if it is not preempted.
And then my other question, I guess, is to Mel. If this, or to Kathleen, if this is vetoed, and I'm not suggesting it should be, but the reality is it's always a reality. If this is vetoed, at what point could it be, if it were vetoed this year, when could the legislature override the veto for this year? What would be the last date that could happen?
Now I'll take the first stab, but yes, depending on when it gets to the governor's desk and is vetoed, there might be an opportunity to override it this session. I'm sure that's what the House and Senate leadership, I would guess, are trying to allow for. Now I have to check. I think it's 10 days before, has to get there 10 days before the end of session, but I would have to confirm that, Mr. President, unless Mel has 100%.
No, it's you always have to remember how they count the weekend days. So, you know, we can get back to you on the exact date, if that's all right. But they would have time to do it if they fall within those constitutional time frames. And again, it's a matter of how they count the weekend days. And I do believe that, you know, they are working towards ensuring that they're able to meet them.
And one last question. I keep saying one last question. This really is the last question, I think. Mr. Latner, while you're checking on all these other things that I've raised, could you please let us know whether or not the council would have the authority to override an agreed upon bargaining issue? If it's already been bargained, and that's with the county executive side, can the council override that bargained agreement? And you don't have to tell us right now, but unless you know the answer right now, but I would like to know that information as well, please.
Well, in general, the council has control over the legislative matters. I mean, the agreements are presented to the council, and any part of the agreement that requires funding or legislation or regulation is presented to the council, as you know, for its agreement, and you do the resolution. So that's not adding this bill, Senate Bill 627, into the mix. But in general, yes, you are not bound because the agreement is made between the executive and the union. It doesn't bind the county council.
Even if it's an effect rather than a dollar amount.
Yes, in terms of legislation, in terms of perspective going forward, yes, the council has the.
No, I don't mean that. I mean retroactive.
Retroactive would raise concerns about the contract clause, and that would depend upon specifically what is at issue. It gets a little more complicated with that.
Yeah, well, I was looking for the more complicated part.
I understand.
So, yeah. Okay.
Could I just chime in there? I believe Mr. Latner was, he was part of drafting the legislation that is before the county council, and he has advised, as Bob Drummer, that what we have proposed is legal. I'm not sure if that's what you were asking or not, but just to be super clear about that, the council legislation has been formulated with that, addressing that concern.
Yeah, I'm not questioning whether what was being suggested was legal. I'm asking about the retroactive part, that we already have an agreement, and I don't know what the agreement, I don't have it in front of me. I don't know what the agreement says, but if we already have an agreement, can we retroactively say that There's no, if the state legislature would allow for it, would we be allowed to change it? That's my question.
Right, I think you have two different questions, and one is the proposed bill, and would that be valid? And secondly, how does this state bill now affect the mix? They're two separate issues.
Two different questions. I think we're speculating and we can get the answer. Council Member Albornoz.
Thank you. Just a quick comment and then a question. You know, I've been reading all the articles regarding the development of this legislation like all of you, and it certainly sounds like, as Councilmember Reamer noted, there's been a tremendous amount of effort by many, including a lot of the leadership right here from our Montgomery County delegation, trying to get this right, acknowledging there are a lot of layers to this. It's a complex issue, legally, civically, professionally, personally, politically. And so I do appreciate these difficult waters that they're navigating, and even the attempt to navigate them to begin with, which needs to be acknowledged. And I do think that they're doing their best to make sure all voices are heard on this issue. And I appreciate this briefing, by the way, helpful to get the context, both as a member of the Public Safety Committee, but also just in general. My question is, obviously we've got City of Tacoma Park, Rockville, Gaithersburg. How would this law affect them? I assume their individual chiefs would appoint their own individual citizens advisory groups, or does MCPD have jurisdiction as it relates specifically to Montgomery County? I'm assuming the other smaller police districts, which are obviously very important, would do this on their own, but just want to confirm.
Yes, and Ed, you can jump in, but the answer would be yes, they would be doing this on their own. The bill as it originally came in, Councilmember Albornoz did have a civilian type oversight board option. That's been taken out of the bill. So when we talk about this bill now, it's a chief making the initial decision about imposing discipline after an internal investigation. And then it's the chief of whichever law enforcement agency it is, appointing the hearing board, which would be to include a sworn officer of higher rank and the two civilians with the characteristics that I mentioned. So, I mean, Ed, you can jump in if you disagree, but it's the individual chiefs who have the authority in a particular law enforcement agency.
I appreciate that. And then this is more of just a general question. This is for you, Chief. So obviously your team, in addition to from a legal perspective and from an operational and administrative perspective, been tracking this closely, as have your colleagues from across the state. We are in a better position than some other jurisdictions because we've already moved forward with enacting some of the language that's in this bill. We obviously have to discuss the preemption issue. I assume that would put us in a better position to comply with or to move forward with some of what is being discussed in Annapolis right now. But just want to get your general view, if you can, on enactment and how this does connect to already standing practices and policies that may already exist within MCPD that we've added to, especially over the last year.
Yes. So thank you, Council Vice President. I think that there's a couple things here. Lots of what the council has already implemented is relevant from a disciplinary standpoint. That the items that are listed here and how we would actually put together a hearing board will change, of course. Through our current system. We actually have, as everyone knows, we have two different types of hearing boards. One you have is a traditional hearing board, which has a senior executive along with another executive, and you have an officer of the same rank. And you have the alternative hearing board, which is the one that comes through our collective bargaining agreement. And that is the arbitrator and one officer who's an executive and one who is an officer of the same rank. Now, the change comes about where we will have to, I as the chief will have to find a panel, I would say a group of citizens. There's not just two, But I think we're going to have a group of citizens who will be willing to serve on these panels and hearing boards, who would have to be extensively trained through the Maryland Training Commission, that would have the ultimate responsibility of administering the training. Would probably have to be trained through our department, and we would have to develop the curriculum to have it approved by the Training Commission. But that extensive training made something that the council may want to have to look at due to the number of hours that will be involved in these types of hearings and the training, to maybe think about producing a stipend or something for individuals, because these hearing boards take considerably a large amount of time. Sometimes these hearings can be anywhere from 3 to 7 days, depending on the level of complexity for any type of case. And this is, again, these are all-day hearings that an individual who has a full-time job may not have the ability to be a participant on this type of a panel. So that's something that's going to have to be extensively looked at by the county, on how we are actually going to have these citizens be a part of this particular this formatted hearing board that would be the change in the new law.
I appreciate that point. I think this is another area, though, where we have a little bit of a jump start. We had over 200 applications for our Police Advisory Commission, and I know the folks that ended up going through the interview process, that was one of the most difficult decisions I've made, because there were so many outstanding candidates who had applied for that position. So I think we should probably dust off that list, although it's not that old to begin with, because I think there are a number of residents who have already stepped forward and expressed a willingness to volunteer on some level. But I take to note, you're absolutely right, wanting to make sure that we do this right, and that there is some level of support given to ensure that we get people who can really dedicate their time and energy and emotion in every way that's reasonable to these very important issues. So I think that will be helpful moving forward. And just a point of privilege, Mr. Council President, I have to jump off pretty close to 1:30. An issue was brought to our attention recently about some pharmacies that are apparently asking for additional levels of information regarding potentially documentation status in order to access the vaccine, which is atrocious. And so we're exploring all avenues to address that issue. So I may have to jump off close to 1:30, but that's what I'm going to be working on. But thank you, Mr. President, and I appreciate this briefing.
No, thank you for doing that. And they're asking for additional forms of ID as well. Very concerning. To be consistent, Councilmember Rice, we also lost to a National Association of Counties call, so we're glad he's representing us well on that call right now. Any other comments from my colleagues?
I texted you twice, Council President.
Beg your pardon, Councilmember Jawando.
So a couple of questions here. I think, the initial bill introduced by Senator Carter was amended, and this is admittedly much, much better than what we have. But there's a couple of things, people are concerned that these extra rights that were afforded to officers, extra than other government employees, different processes, create an issue when it comes to, one, transparency, but also accountability. And I guess if the staff could help me just point out, and for the public, the differences, one of which I believe, what are the differences between what a state and government employee, the rights that they have, any government employee would have, that still remain in this amended bill? Has that analysis been done in that way?
Councilmember Jawando, I can't provide that type of analysis right now, nor has it been, to my knowledge, done in any written format or comprehensive way at the General Assemblies. Although discussions, certainly the voting sessions have involved discussions about differences between certain parts of state law governing state employees and officers. But I personally can't provide that kind of analysis, but we could look for more information for you, or perhaps Mel or Ed can offer.
Miller, Ed, no. I see nodding heads. No.
Yeah, I could just tell you it's section 3103, and it is, I believe, word for word what is in the present LEOBR, which prohibits, the law enforcement agency from retaliating against the law enforcement officer for exercising rights under the statute, prohibits in general financial disclosure by a law enforcement officer.
So some similar provisions. What about the expungement? That provision was one that was a change, correct?
Right there. I mean, you mean a change as compared to other state employees, or a change? It was added to the bill for sure.
Yeah, added to the bill from the original bill, but also related to other employees in the state. Do other employees in the state have that same provision that you're aware?
I personally don't know of that, but happy to get back to you on that.
Okay, I think the answer is no, but I would, I don't know, but I'd love to. That's my understanding that it's no, but I think we should confirm that. The point being is that I think most residents, myself included, want to see the same set of rules for everybody, and they want there to be transparency and accountability around those rules. I do think that the changing the disciplinary point of accountability from these very long drawn out processes to giving more authority to the chief of the department does create a better system in that, and that's why I co-sponsored the bill, in that you have one point of contact. You have one person who's, if accountability isn't happening sufficiently, that person is subject to appointment and oversight by the elected leaders in that jurisdiction. However, I think the bill that Senator Carter introduced was better in that you had the ability, if an officer, for example, which has happened here in Montgomery County, was convicted of a crime or pleaded out for probation under the original bill, and I would like you to confirm this, that the chief could then take this action right away, as opposed to having to go through this trial board process, even the altered trial board process. Is that correct?
Well, I mean, what I can tell you the final bill does is it does give the chief, as I mentioned earlier, it does give the chief the authority to act without conducting an internal investigation if an officer has been convicted of or received probation before judgment for a criminal offense. And I didn't mention the specific crimes before, but it's a criminal offense that was committed in the execution of the officer's duties or bears on the officer's credibility, integrity, or honesty, and relates to the alleged misconduct. So for officers that fall into that category, the chief
he has that authority.
Retains authority to impose discipline without going through an investigation.
Got it. And then last question I have, I guess, Councilmember Arbonaz was, I think, barking up this tree. The citizens members that are picked and how they're trained, who has the authority to decide? Can we legislate in that area under the current bill? Could we put requirements around who and how or is this totally preempted and it's just what the chief picks them and they decide what training they receive? What's the boundaries of that?
Yeah, the bill itself specifies that the civilians must receive training from the Maryland Public Service Training Commission, Public Safety Training Commission. They cannot be employed by a law enforcement agency, any law enforcement agency, and can have no current affiliation with the chief, law enforcement, or the matter to be reviewed by the hearing board. And then the bill does require the Maryland Public Safety Training Commission to develop training that civilians must obtain and complete before serving on these hearing boards.
Right, but my question is to the appointment, and I understand. I read all of that. My understanding of just reading it is that the chief has the sole appointment power. That cannot be modified by the council.
I'll let Ed take it, but that it's very specific in the bill that it's the chief that appoints, and the preemption language is very clear. So to me, and so my sense would be there's no local authority in that area. But I heard our county attorney.
Yeah, the wiggle room, if you will, that the county has is the gap filling, is regarding the investigation, interrogation, polygraphing, drug and alcohol testing. The other matters are the counties are expressly preempted from legislating. It was eased out. The room was given to the counties because those sections are no longer addressed in the LEOBR, the investigation, interrogation, the polygraph, so there was an empty space there. This will allow the localities to fill it. But the appointment for the civilian members is dealt with in the LEOBR, so I think that would fall within the preemption.
Okay. Well, I appreciate that. I think, last question I have, are there any major changes, or maybe we can come back for what the House bill? I know there are some people seeking changes in the House bill. I guess we'll be briefed on that another day. Is that the plan, Mel?
That would be the plan. We do know that they acted Friday night, but it's just we don't have amendments. And we believe that there are substantial changes in these packages. So as soon as we see a set of amendments or see a third reader bill, that's when I think we can provide you a safe, credible comparison of what's going on. Right. And that would be next time we meet, or we could send something in writing in between.
Yeah, I appreciate that. And thank you, Mr. President. I don't know how long we're going, but I'm happy with overall in the direction that we're heading. I think there's improvements that'll be made, but happy to head in this direction. Thank you.
Right. No, I agree with everything that's been said about how significant this is. And I'd be surprised if everybody thought it was perfect. I don't see any other comments, requests to speak on this bill. So Mel, I think we can move on to the next one, or Kathleen.
Okay, let's just then, if it's okay with you, let's just start back at the first page, and we'll we'll see how far we get here.
Sounds good.
Okay.
Okay, so back on Senate Bill 71, this bill deals with body-worn cameras, and for counties other than Montgomery County, Baltimore City, Baltimore County, and Prince George's County. Well, I should say those 4 counties that I just mentioned currently have body-worn camera programs. The bill would then require the following jurisdictions to implement body-worn camera programs by July 1, 2023, and it's the State Police, Anne Arundel County's Police Department, Howard County's Police Department, and Hartford County Sheriff's Office. The idea being that these larger jurisdictions would have a mandate by July 1, 2023 to require any officer who regularly interacts with the public to use a body-worn camera. Actually, the 4 I mentioned, Montgomery County and the 3 other counties, aren't even mentioned in the bill, although there were discussions during the voting sessions that these counties do already have their programs. For municipalities and for other counties, the deadline for implementing that body-worn camera requirement is July 1, 2025. Having said that, the bill also creates a task force to study issues relating to implementation of these kinds of programs, and to report and feasibility for, I think, particularly the smaller counties and municipalities in terms of implementing the programs. And that report is due by July 1 of 2022. In terms of Montgomery County, under current law, the Maryland Public Safety Training Commission has to adopt a policy regarding the use of body-worn cameras for all law enforcement agencies. And in the memo on page 2, it's very detailed, the components of the policy that the MPSTC must develop. And the bill specifically then specifies that any law enforcement agency's own internal policy must comply with the MPSTC's guidelines. From Montgomery County's perspective, I think perhaps the biggest change would be just that there's a rebuttable presumption that's created if an officer intentionally fails to activate a camera in violation of Montgomery County Police Department's internal policy. There's a rebuttable presumption that the testimony by the officer is inadmissible in a criminal proceeding. And there is a way to show and rebut that presumption, which we could speak to if that's important, but that's an important component of the bill. And unless there's questions on that, Mr. President, I would move on to Senate Bill 74.
Sounds good. I don't see any requests.
Okay. So this next bill, it's on page 3 of the memo. It repeals a requirement of current law that an agency must establish a confidential and non-punitive early intervention policy for counseling officers who receive 3 or more complaints from members of the public within a 12-month period. And it substitutes a new requirement that an agency establish a system to identify officers who are at risk of engaging in the use of excessive force and to provide officers with training, behavioral interventions, reassignments, or other appropriate responses to reduce the rise of excessive force, the use of excessive force. In terms, I suppose there are some other details in terms of what that program must look like. And in particular, it has provisions about action that an officer must take if they've been involved in certain types of incidents before they return to work. So for example, an officer who is involved in an incident resulting in serious injury to the officer, or often involved shooting or use of force resulting in fatality or serious injury, is subject to mandatory mental health counseling and voluntary counseling services. If an officer is involved in an accident resulting in a fatality, an accident, then it's voluntary mental health consultation and voluntary counseling services. So in the one case, it's a mandatory mental health consultation, and the other, it's voluntary. And in both cases, the services themselves are voluntary. So those are the key provisions of that bill. And if there are any questions, Mr. President, can handle that or move on.
Sorry, I don't see any requests. I think we can move on. Thank you.
Okay. So this next bill, this next bill is the bill dealing with Maryland Public Information Act and personnel records. And so as I think everyone here is probably very familiar with, under the Maryland Public Information Act today, if there's a personnel record and somebody makes a request to inspect and see those records, there's a mandatory denial that's required by the custodian of those records, except in 3 limited circumstances. If it's your own records and you're seeking them, you can get them. If you're an elected or appointed official and you supervise the work of an individual, you can get them. And there's also another, a third unusual circumstance where collective bargaining organizations for public school employees can get contact information for new employees. But other than those exceptions, if it's a personnel record and someone makes a request for it, can't get it. This bill turns that mandatory denial into a discretionary denial for records relating to an administrative or criminal investigation of misconduct by an officer, including internal affairs, investigatory record, the hearing record, and any record relating to the disciplinary proceeding. So those records get taken out from underneath the mandatory denial, put into a discretionary category. And then there's provisions of current law that govern other types of investigatory records that are then triggered by that change. So a custodian would essentially not be able to deny that request unless a number of different circumstances exist. And those circumstances are specified on page 4. So a custodian could deny if it would interfere with a valid and proper law enforcement proceeding, deprive another person of a right to fair trial or impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, or endanger the life or physical safety of an individual. So it's a very major change to our Public Information Act, and one of the very, very controversial aspects of the policy issues being debated in Annapolis. And it will be one of the areas where there will be some differences between the House and the Senate.
Okay, don't see any comments, questions. Oh, Councilmember Jawanda.
I'll just say briefly, we had taken previous positions in previous years about MPIA reform. This is a big deal. It interacts with the reports that are done with the LED Act on a police-involved death. It allows, just creates a much more transparent environment. So I'm really just wanted to say that this is a big deal, a major change, and want to congratulate. Hopefully we're not there yet, but hopefully this can go through, because it really, really gets in the way of the public knowing what's going on, so that we can improve these situations safety on both sides. So thank you, Mr. President.
Thank you.
Mr. President, I just wanted to mention and turn it over to Mel for the next bill. The bill does have an exempt, the bill keeps records relating to what's called technical infractions, still keeps them as personnel records, and defines that term in the bill. So just didn't want to be inaccurate.
Thanks.
Okay, so we'll keep rolling through then.
Yep.
So I'll pick up where Kathleen left off we're on page 4 of the memo on to page 5. And there is a piece of legislation that passed that has to do, it limits the use of no-knock warrants and also speaks broadly to reporting requirements for all warrants. So the first thing that happens is if you are going to apply, if an LEA is going to apply for a no-knock warrant, you have to include information in that application about who may be on that property or in the residence when you might be serving. Also, they are pretty restrictive about, in the bill, speaking to a time period within 10 p.m. and 6 a.m. And you have to serve warrants outside of that unless you make a case, unless you justify in the application why you want to serve the no-knock in between those hours. And if you do, you need to try and provide specificity as to the time that you will be serving it. As far as authorizations, the actual warrant needs to reflect all of this information. And then they limit the amount of time that these warrants, a no-knock is good for. It's for up to 10 days unless there's a case made which would allow it to be 15 days. And then it's not just the judge who makes any final determination. Before execution of the no-knock, it's going to go through another level of review. It's going to go to the state's attorney's office or his designee, and then it's also going to go to the command staff for another check on very specific issues that I've listed on page 5 of the memo. And then when the warrant is being served, there's requirements about what type of clothing has to be worn by the officer. And also the fact that when you make entry, you're supposed to alert individuals inside the premises that you're there, and you need to leave a copy of the warrant behind. And then there's some extensive or additional reporting that's required, not just of no-knocks, but of all warrants. And I've listed those on the bottom of page 5. And also in the piece of legislation, it requires reporting of 10 specific variables that are listed in the bill. But just to give you an idea, it's, how many times, this is an annual report that each LEA has to submit. And it's got to be in a very specific format too. And this has been a problem in the past. There was loose reporting of information, and also there was no format by which it was supposed to be reported. So there is a format, it's an annual report, and it speaks to even SWAT teams in this case, how many times they served a warrant, where the warrants were executed, whether a domestic animal was killed, a number of pieces of information that have to be required. And then it requires the Governor's Office of Crime Prevention, Youth and Victim Services to analyze and summarize all those reports, do their own report, post that on a website. And then if you don't do it, if there's an LEA that is in non-compliance, there are consequences. At least you're reported to the General Assembly's Legislative Policy Committee. And so there's some notification of that. And that's how that one's working. If there's not any questions, I'll go on to the second.
No, Councilmember Clark.
Thank you. And Mel, I've been asked if it's a federal marshal. I do not know this answer, but if it's a federal marshal that has a warrant, since this is state legislation, does the federal marshal have to follow the state law on this?
Being a finance MBA and not an attorney, I don't know for sure, but I think the answer would be no, but I'm going to turn it over to Mr. Lantner for that one.
Being an attorney, I'm not certain of the answer.
Okay.
I would think no also. I don't think it would limit a federal officer.
Okay, thank you.
Thank you.
All right, roll on.
Yep, roll on, please.
Right, the next one is just about surplus military equipment, and this is a simple short bill. It just prohibits a local law enforcement agency from receiving weaponized aircraft, drones, or vehicles, or grenade launchers, destructive devices, or firearm silencers from federal government-operated surplus military equipment programs. The next bill has to do with who does investigations in homicides. And what Senate Bill 600 does is it requires the state's attorney who has the jurisdiction to prosecute a matter of the death of a person to, if they are not going to pursue the matter, provide within 10 days of finalizing the investigation a copy of the investigatory file to the office of the state prosecutor. And the state prosecutor, if they decide that that decision was incorrect, they can prosecute the case. And they can not only just prosecute the homicide, they can also go after any other crimes related to the incident. And then in addition to this, because this has been, there are different ideas about how this might be done, the bill creates a task force on independent investigations. And that task force is supposed to report at the end of this year, and they're supposed to look at what are best practices, what should be the blueprint for such an investigation. And they're also supposed to make recommendations on the potential establishment of an independent agency to do this type of work. All right. Sure.
Councilmember Joanda.
Thank you. Yeah, I just wanted to chime in on this one briefly. It's as there have been several bills bouncing around, and I had gone and testified on over the last several years. This is in line with requirements of this council's first bill, the LED Act, to require independent investigations when a police officer is involved in the death of a resident. And there are other proposals to the second part of this bill, as Ms. Winger mentioned, to try to have the Attorney General be involved in the investigation or look at all these different models. So I think this is movement in the right direction. Hopefully we'll get to a place where we have a statewide investigatory body for all of these, but that'll be studied under this bill. And at a minimum at this point, at least the prosecutorial decision will be reviewed, and that will be independent in some way or form. So thank you, Mel, and just wanted to chime in on that. Thank you.
Also note, it looks like this has an upfronted enactment date. I think it's June 1st. So they're hurrying on this one. I think this is the last bill, since we've got through Kathleen's, involves use of force and whistleblower laws. So Senate Bill 626 creates two new subtitles, one in the criminal law article that creates for the first time a statute that defines use of force and lays out kind of all the ground rules around use of force. And then it also creates a new subtitle in the public safety article that relates to whistleblower laws. So it defines use of force, force that an objectively reasonable LEO would conclude exceeds what is necessary to gain compliance, control of a situation, or protect an LEO or other from harm under the totality of the circumstances. So that's the definition that will be in the state statute. It also has it includes a provision about duty to intervene, and it also includes a provision about the requirement that you provide or obtain medical assistance if someone's injured. Also says that if you witness excessive force as another law enforcement officer who is on the scene, you must immediately report that. And it also says if you are convicted of using excessive force or failing to intervene, you're subject to substantial penalties, including imprisonment. On the training front, there's also a lot having to do with the training of this. It requires the Maryland Public Training Safety Commission to include training in their programs regarding individuals who are in crisis and the requirement to intervene or terminate or prevent the use of excessive force. It adds to the list of violations where you can lose your police certification where you failed to de-escalate or you misused less lethal force. And less lethal force, I believe, is things like mace, pepper spray. I don't know if it also includes stun guns or not, but there's a defined term of less lethal force. And it requires each LEA in consulting with the commission to establish, maintain, and implement policies and guidelines regarding the use of force, de-escalation, and protecting officers from retaliation. And it also requires, by July 1, 2022, each LEA to annually budget for this type of training, and also for ability to assess supervisors in the reinforcement of all these training objectives and the training programs. It creates a whole section 2 about reporting. It requires extensive reporting. The first report's due by December 21st, and every 6 months thereafter, LEAs are required to report, again, on a standard form to the Governor's Office of Crime Control, Prevention, Youth, and Victim Services, a lot of data regarding the use of force, complaints, hospitalizations, and they want a lot of the data disaggregated.
Right.
And then it requires that the Governor's Office of Crime Control to analyze, summarize that data, create their own report out of it, and put it up on a website. And, yep.
No, I just think we have to keep rolling. We have a very thorough packet. I'm sure everybody's.
Alrighty. Well, let's just call it, let me just move to whistleblower, but no surprise there. You get your state aid withheld. Yep. And there's also a new whistleblower section that is included, and I will let you read that yourself.
Great.
And that's it.
Any other comment from Councilmember Jawando?
No, I think that's an old text, so I'm good to go.
Great. Okay. I see no further comments and requests to speak. So thank you all so much for the update. We really appreciate all your hard work, and we'll see you again soon.